Hello everyone and welcome to my talk. My name is Tali Shammas. I am an agented writer, I'm a literary intern, and I'm also a lawyer. And so I've melded all of my areas of expertise to compile this presentation for you on legal issues all writers should be aware of. Now, I will say I'm going to get into this in the slides, but my first tip for any writer is seek independent legal advice. Nothing in this presentation is intended to be legal advice, but I am educating you on legal issues you should be aware of. I also want to just quickly say that my kids brought home some lovely bug and my voice is going in and out, so let's hope it holds for the presentation, but fingers crossed. So let's get right into this. So there are lots of different areas of law that apply to writing, from contracts, defamation, copyright, trademark, plagiarism, sources. We are going to limit ourselves to the first two today, which are contracts and defamation. But if you have questions on any of these other areas, I do offer workshops and you can get in touch. My website is talishammas.com and you can reach me at hello@talishammas.com. Okay, so let's get into contracts first and foremost. So as I mentioned, my first piece of advice for any writer that comes to me with a legal question is consult a lawyer. Consult your own lawyer. So don't go to, a friend who might have gone to law school, but call up a lawyer in your area that practices publishing law. That is very important. At least entertainment law, which is kind of the broader area of law at play here, because you'll want someone that's an expert in this area. Most lawyers offer free consultations. I know they are pricey, but they will speak to you for a little while to get a feel for your case without charging you. And if they don't, then, look for someone else. But also there are pro bono legal clinics that exist. I know I volunteered for one of these when I was a law student, and essentially based on a certain income threshold, you may qualify for free legal services. So look into that in your area. But anytime you get a contract, your first step, unless it's really standard, really boilerplate, is to have a lawyer review it, and specifically a publishing lawyer, because publishing contracts are often quite unique as opposed to other types of contracts. So you'll want someone that's familiar with the standard terms. To give an example of why you might want a publishing lawyer, someone well-versed in this area of law, I know someone who signed with an agent recently and who had a real estate lawyer. So they actually paid their real estate lawyer to look over their agreement with their agent, and this just wasted a bunch of time because the agreement was very boilerplate. But the agent, real estate lawyer, was bringing up all of these kind of clauses that they thought were funny or unusual, and all this did was cost a lot of money and waste a lot of time because they weren't really aware of what was typical in a contract with an agent. Okay, so we are going to be discussing 3 different types of contracts today. We'll be discussing publishing agreements, agent contracts, and editor contracts. I'll also touch on work for hire agreements, but these are less common, so we'll try to breeze over them. So when it comes to publishing contracts, they can be complex, and authors really should understand the key aspects of these agreements in order to protect their rights and ensure a fair deal. So the main things authors should be aware of are ownership. So who owns the copyright? You should retain ownership of your work unless there's a compelling reason to transfer it, for example, in a work for hire scenario. So generally what you're doing is just licensing the rights to your work, but you still retain that copyright, which allows you to control future adaptations, translations, licensing opportunities, all of that. And then you want to just be really cautious about what rights you're granting. So if, for example, your contract has very broad language, like you're granting all rights, that means you're granting everything: print rights, ebook rights, audio rights, translation rights. So you want to grant only the rights that the publisher needs, for example, print rights or ebook rights, and retain the others like film, TV, and merchandise rights. In terms of advances and royalties, so advances are the upfront payment you receive against future royalties. So once you sign a book deal, you will get a certain advance. That's what you see in Publishers Marketplace with a nice deal, a good deal. And then that advance will be essentially paid back if you don't earn it out through your book sales. So you'll want to confirm the amount of that advance, of course, and then, typically these are paid in installments. So you'll want to know exactly when you will receive these installments. So, on signing, on delivery, on publication. And then in terms of royalties, you'll want to understand how they're calculated. So are they calculated based on the retail price of your book? on net sales. And there are generally common rates of royalties, so you'll want to know exactly, what rate your royalty is, but you can expect for hardcover books these to be between 10 to 15%. For paperback, they can be between 6 to 10%. Ebooks are generally higher, so you'll have 25 to 50% royalties. And then we have to talk about escalators. So some contracts actually increase royalty rates after a certain number of copies are sold. And so, this is really important to have in your agreement, because you'll want to know that, the more copies you sell, the higher your royalty rates go. So that's something you'll want to talk about with your agent, and just make sure that you know exactly what you're getting into, if you have an agent, of course. And if you are entering into a publishing agreement without an agent, please, I implore you, have a lawyer look over it. An agent generally will be an expert in these types of agreements, especially if they've been practicing for a while. If not, then, see if they have a mentor, someone at their agency who has expertise in this area to look over the agreement, make sure you're getting a good deal. But if you don't have an agent to look over an agreement for you, there are agents who are also lawyers who do freelance, legal review. Please retain one of them. Please make sure you're getting a set of eyes on this to know that you're not doing anything that could harm you or your career. Okay, let's talk about subrights. So these are additional rights the publisher may want to gain, such as film and TV, audio, foreign translation, merchandising. And so you want to generally negotiate for a higher revenue split on these, or you want to retain them to negotiate them separately. So let's say, for example, your publisher wants the print rights to your book, but they also say, oh, we want to keep audio as well. If they're giving you kind of a lower rate on audio, you might want to just keep audio to get a deal separately somewhere else so that you can get a better deal. You don't have to give your publisher everything. You definitely have room to negotiate. Okay, let's talk about termination clauses. So, typically writers will think about ownership, they'll think about royalty rates, they'll think about, the rights, all of these things that seem very key. And then a termination clause might not seem that important. Who cares? I don't want to terminate this agreement. I don't want to think about this. A termination clause is actually one of the most important clauses in any agreement. You want to know, if things go wrong, how do you get out of it? So they're critical for outlining the circumstances under which the contract might end and the consequences of termination. So essentially what you should know is that, there are certain grounds for termination. So for example, breach of contract is a ground for termination that either party can use. So if you want to terminate and the publisher has breached the agreement, you can say that, they've failed to fulfill their obligations, they've missed deadlines, they haven't paid you, they failed to publish, and you want to terminate the agreement. But on the same token, the publisher can say the same thing for you. If you breach the contract, they can terminate. Now, there are specific grounds for termination that are author initiated. So for example, failure to publish, they don't publish, you can terminate the agreement. And you definitely want to have specific terms in the agreement that set out exactly how you do this. So there has to be a timeline. For example, like if they don't publish within X number of years after receiving the or accepting the manuscript, then you can terminate. You don't want to have this very vague, broad language that sometimes you have in publishing agreements that can really backfire on the writer. You want all your terms to be crystal clear. Now, in terms of what happens upon termination, you want the rights reversion language to be very clear. You want all the rights to be reverted to you upon termination. So if, for example, you terminate, but they keep the rights, then, if they're not publishing that book anymore and you as the writer want to get that book published, you can't do anything because those rights haven't reverted to you. So you want to make sure that those rights go back to you. And you also want to know, in which instances can a publisher terminate the agreement. So, for example, if the manuscript is unsatisfactory, that's a general reason why the publisher may be able to terminate, but you want to know exactly what constitutes an unsatisfactory manuscript. Like, what are their standards? How many rounds of revisions do they get to ask you to do before they can terminate? Also, some contracts actually allow publishers to terminate if the author's actions harm the publisher's reputation. So you want to be very careful about, what you're posting on social media, what people know about you, and how that might affect your career. Out of print clauses are also, very important. I alluded to what happens when, a publisher stops printing your book. So you'll definitely want to have that stated clearly in your agreement. What constitutes out of print? Like, how many copies do they have to print per year to still be considered in print? If they print one copy in a year, is that considered in print? Seems like it shouldn't be. So, you really want to know when you can terminate. And, you want to look at other important factors like post-termination. Will you still get your royalties? What happens to subrights and third-party rights if you terminate? If your publisher has sold them, for example, do those also terminate or do those continue? So you'll just really want to know what happens on termination. It's very important. You'll want to know what notice period has to be given. Just generally anything to do with termination, make sure that you understand very well. So let's talk about self-publishing concerns. I don't want to spend too long on this because my focus is generally traditional publishing. But in terms of self-publishing, there are certain things you'll want to know about. So for example, you'll want to know if you're working with a publisher, a hybrid publisher, what are the upfront costs? What are the revenue splits? What exactly, is your responsibility? ISBNs are very important. These are international standard book numbers. I believe in Canada you can get one for free. I'm in Canada. In other countries like the US, I think you have to purchase them. So when you purchase your own ISBN, you essentially maintain complete control over your book's metadata. But then if a self-publishing platform like Amazon via Kindle Direct Publishing provides the ISBN, they might be listed as a publisher instead of you. And that could actually impact your brand and your publishing rights. So you'll just want to look into that, like who owns the ISBN. And owning an ISBN is generally, a good idea. It makes your book look more credible. So it is something you'll want to look into. And then you'll want to be very aware of your distribution contract as well. So if you're distributing via Amazon KDP, Ingram Spark, Draft to Digital, you'll want to know whether you have to be exclusive with this platform or whether you can, distribute to multiple platforms. And you'll want to know also what the revenue split is. So typically these platforms will offer royalties based on your book's sales price, but the percentages can vary. So for example, Amazon might offer 70% royalties for ebooks at a certain price range, like $3 to $10, but only 35% outside of that price range. So you'll want to be very aware of that. Now, in terms of agent contracts, so these are contracts when you're going out and you're looking for a presentation from an agent. What are you looking for in these agreements? Now, these agreements are generally quite standard. So, more or less you're going to have the 15% commission. You're going to have, them representing a certain body of your work. So they'll say they'll represent, all the full-length novels that you write. There may be some stuff that falls outside of the scope of what they represent. So for example, you might want to clarify, well, if I write short stories, let's say I want to submit to Lit Mags, are you going to represent that as well? Probably not, because your agent is signing you for your full-length books. So let's talk about the key issues that can come up in these agent agreements. So in terms of the fees, so there are the royalties and the commissions that go to your agents. So as I mentioned, industry standard is generally 15%. But an agency may also take fees for printing your work, for distributing your work. So you'll want to be very aware of exactly what they're going to be charging you for. And that'll all be set out in your agreements. Now, in terms of the scope, as I mentioned, that's, are they representing just your full-length novels? Are they representing short stories? What falls within that scope? What doesn't? Are they representing you for one book? Or are they looking at you as a career writer? Are they going to represent every single book that you write? Does it matter what genre you're writing in? So if you're writing, let's say you queried them with a fantasy novel. If you want to get into some different genre, let's say you want to work on literary fiction in the future, will they represent that? What if you want to work on, a thriller or something, or even move into nonfiction? Is your agent comfortable representing you across different genres? So you'll definitely want to bring that up on the offer call and also check what your contract says about that. You'll want to look at the rights that are granted to your work in your agreement as always. And then again, that termination clause is so key. Amendments are just, if there are any sort of almost like appendices that change certain clauses in your agreement, you'll want to see if there are any of those. but generally that's what you want to look out for in an agent contract. If you have any friends, for example, when I was signing with my agents, I had a friend who had compiled a list of all these different agency contracts and what their kind of standard terms were and what there was to look out for. You might want to, see if you can find any resources like that. That's always helpful to know what's industry standard, especially in an industry that's so opaque. And now, one thing that you will want to keep an eye out for as well, now that I think about it, is if your agent is signing you for publishing focused work. So let's say traditional publishing. If you want to sign with an agent and have them send your work to publishers, does that agent also get to represent your self-published work if you have any? You'll want to consider that, especially for writers who may have been self-published before they looked into kind of that traditional publishing route. You'll want to make sure that you know what you're getting yourself into. Okay, so now in terms of editor contracts, so these are contracts more often than not with freelance editors who will look over your work. So this is, either you are the writer and you're retaining someone as an editor, or maybe you're the editor and you're looking to enter into a contract with a potential client. What do you want to look out for in either case? So again, we want to look at the scope of the agreement. Are they retaining you, or are you retaining them for this one piece of work, for a portion of this one piece of work? Are you retaining them if it's a series for 3 books, and what will the deliverables look like for that? Also, are you retaining them for developmental edits, which is kind of like the flow of your story, for line edits, for copy edits? What exactly are you looking to get here? That needs to be set out clearly in your contract. You'll want to set out the compensation. Is it, half upfront, half at the end? Is it in installments? Is it upon delivery of whatever the deliverables are? And then you'll get into that timeline. You'll want to have, a confidentiality clause just stating that the editor will not divulge the property essentially to anybody else. And then of course, once again, that termination clause is just so important. Okay, now in terms of work for hire agreements. So work for hire agreements are these instances where a writer will get contacted by whoever it is who has a specific project that they want them to write, and they will pay them a flat fee. So this can be like an IP work that, they'll say, we want this Star Trek book written, for example, and they will put out a request. You'll submit usually an application, and if they select you, then you'll basically write this book that they give you the story for, and they just tell you, write this. So you're given a flat fee for the work, and generally in this case, the ownership of what you write doesn't belong to you. It actually belongs to the person that's hiring you. And so that's different than when you write a manuscript and you're querying it or you're submitting it to publishers. In that case, that copyright belongs to you and you're selling a license basically to it. But in this case, the copyright belongs to whoever's hiring you. So you'll definitely want to know the scope, like how long does this book have to be that I'm writing? What am I writing here? What is it supposed to look like? And again, like with an editor, you'll want to know the payments, the deliverables, and the termination clause, as always. Okay, so now we get to the second part of our presentation, which is defamation. So defamation is an act, and it generally falls under 2 categories. So it's libel or slander. So defamation in general is when one party accuses another of spreading harmful lies. So libel is written defamation and slander is spoken. So we will be sticking with libel today because writers, we write. So what is a type of defamation or an example of defamation that writers often worry about? Why do I get asked this question so often? So this generally comes up in the context of nonfiction. And so I will have people coming to me and saying, hey, I really want to write my memoir. But for example, my husband was horribly abusive, my ex-husband. And I want to write about this, but I'm scared that he'll be able to sue me. So what can I do to protect myself? Okay, well, let's start with how you prove that defamation occurred. So there are 3 things that somebody has to prove in order to show that defamation occurred. So in my example, it would be the ex-husband proving these 3 things to show that the writer committed defamation, or libel rather. So first off, there has to be a statement made by the defendant, that would be the writer in this case, about the plaintiff or the husband. So the ex-husband would show the book, they can show that statement was made, they make that out. The second part is a reasonable person has to conclude the statement harms the reputation of the plaintiff or the husband. So a statement stating that they're horribly abusive would harm their reputation. So yes, this would fall under the second head. The third head, the statement was communicated to at least one person other than the plaintiff. So if it's a book that's going out to the general public, then that satisfies that head as well. So that means if you write this nonfiction memoir, then it is defamation. However, the thing about defamation is that it often comes down to the defenses. It's very easy, essentially, to show that someone defamed someone else, but then you can say, but there are these defenses. So yes, I did defame them, but either it was a true statement. True statements are not defamatory. So if this abuse actually happened and you have evidence that it happened, that is not defamation because it is a true statement. It can be fair comment. So this is statements or comments on matters of public debate. So essentially this is generally, journalists reporting on things that may be matters of public debate. It can be seen as fair comment, and that is defense for defamation. Or it can be a responsible communication on matters of public interest. So these are matters of public interest. This is essentially most likely applies to media or the newspaper. And it's just, stating that this is an issue that applies to the public. This is something that we should be getting across to them. So again, that wouldn't really apply to, a memoir writer, for example. But these are defenses to defamation. So usually writers will turn to this first defense that it is a true statement. If it is a true statement, it is not defamation. Okay, so how, as a writer, can you protect yourself in the first place from a claim of defamation, from someone even being able to say you defame them? So first off, you can change parties' names, but this isn't really foolproof because you don't need to identify a person by name if you can identify them by other factors. For example, if you're writing a memoir, you've only been married to one person and you describe an abusive ex-husband, even if you change his name, it's easy to identify who this person was. So that just shows you one of the pitfalls to this. But you can also consider the statement's purpose. So if it adds value to your story or serves a greater purpose, then that is less likely to be defamatory. If a statement is just made carelessly without regard, it's more likely to be defamatory. Okay, now what happens most often when somebody wants to write a memoir and paint somebody in their life in a negative light is they will wait for them to die. So for example, we think of Jeanette McCurdy's book, because you can't defame someone who is not living. So that's usually my advice for writers, to be honest. I say if you want to write something that truly paints someone that, is a part of your life in a very negative light, wait until they die. That's the safest way to safeguard yourself. So what happens if somebody actually does sue you for defamation and is successful? I will say this is not very common. I don't think it's a concern that writers really need to worry about, especially if they're being responsible about their material. But remedies in a successful defamation suit can include things like damages, injunctions. An injunction, so damages, first off, is when the court requires you to pay someone. So they can require you to compensate them. Let's say your defamatory statement caused them to lose their job. The court can order you to pay them for a certain income. An injunction is just, ordering you to stop doing something. So that could be stop selling your book, stop making defamatory statements. It really depends. And also you can compel action, or the court rather can compel action to rectify harm. So that means remove the statement. So, go back, edit the book, take that out. So it is quite, it can be quite burdensome if you do end up having someone sue you for defamation. So that's something to keep in mind. Anyway, this is the point in this presentation where I generally open the floor to questions. But I guess because this is a recorded clip, you can't really ask me questions here, but my email is always open. You can reach me there. I am not extremely active on social media right now because I am deep in the throes of editing my own novel, but I always reply to emails, so just reach out to me. I hope that you've found this presentation to be informative. I hope that you've learned something, and thank you so much for watching. Have a great day.